Greetings everyone present here. I am Anjali from the team of Lexis and Company, and today I'll provide you a brief on one of the most, actually two of the most famous general defenses provided under Section 82 and 83 under Chapter 4 of the Indian Penal Code. Section 82, it enshrines the legal maxim of Doli Incapax. Okay, and what does Doli Incapax mean? It means that a person is incapable of forming a criminal intention. Okay, so as per Section 82, I'll read it out for you. Okay, so it says, nothing is an offense which is done by a child under the age of 7 years. Okay, so it is believed in our criminal system that a child under the age of 7 is completely incapable of forming a criminal intention, and he's hence it is that mens rea is one of the most essential. It is an essential of a crime, right? So if you're incapable of forming a criminal intention, so definitely you're incapable of the crime. So anything done by a child under 7 years, it is not considered to be an offense, even if it is murder, even if it is theft or anything. I'll give you an illustration. um, Suppose A, who's a child of let's say 5 years, uh, by mistake he uses his uh, father's gun and he shoots his father, and unfortunately his father dies. So here the child A, since he's under the age of 7 years, it will be considered that he had no intention of doing this act, and hence it will not be considered to be an offense. Okay, then it will. Then let's talk about Section 83. I'll read it out again. Nothing is an offense which is done by a child above 7 years of age and under the age of 12, who has not attained sufficient maturity of understanding to judge the nature and the consequences of his conduct on that occasion. Okay, so here the line that he has not attained sufficient maturity, the sufficient maturity given under here is on the discretion of the court. It is on the court to see the previous and subsequent conduct of the child under the above the age of 7 years, but under the age of 12 years. Okay, so the court will analyze according to his actions, according to his words, according to his conduct, and see that if that child has the he has the maturity to understand what he is doing and what the consequences of such act will be, then it will be considered to be an offense. But if that child does not have the maturity of understanding the same, then he will not have it will not be considered to be an offense. Okay, this principle the principle enshrined under 83 is Doli Capax. Doli Capax is the opposite of Doli Incapax, and it means that the person is capable of forming a criminal intention. So, although it is opposite, like Doli Incapax and Doli Capax are opposite of each other, but both are used as criminal defenses. Okay, so let's look at some of the case laws under this under these sections. Okay, one more thing, that the criminal procedural code, it provides for a presumption. Although 83 says that if the child has attained sufficient maturity, then it will be the offense will be considered to be an offense, right? But CRPC provides for a presumption of innocence in this case, that the burden of proof will lie on the other party. The child who is above, although he is above the age of 7 and under the age of 12, he will be presumed to be innocent. Okay, so the first case we'll see is Hiralal versus State of Bihar. So what happened in this case was that a boy of 11 years, okay, and he threatened to kill a man, and he said his words were like that, I'll cut you into pieces, I'll stab you. And then he actually goes ahead and stabs the person and it kills him, right? So the court here, the court uh, takes the discretion here, that the person has attained a sufficient the child has attained a sufficient maturity, I'm sorry, uh, by his previous and subsequent conduct and by his words, basically, right? So the court goes ahead and convicts the child. The second case is R versus LMW. Here, the child of 10 year, he knew that one of the child who's playing with him, who was of 6 years, he could not swim, but the child still dropped him into the river, right? So here also, the knowledge of the fact that he could not swim, that makes the child, he'll know the consequences of what he is doing. So here also the court convicted him, and here in both of these cases, the Doli Incapax, it was rejected by the court. Okay. So there was another case wherein there was a child of 6 years, and the child found a gold bangle lying on the road, which he took home and he went ahead and gave it to his mother, right? And here the child will not be considered to have committed the offense of theft or any offense for that matter, because he did not have the sufficient understanding, and also he is under the age of 7, so that does not, the court will not take the discretion here. But if he was above the age of 7 and he would have taken the bangle home, then the court will take the discretion to look at the fact that if or not he has the sufficient understanding of this offense to be called as theft. I hope you liked the lecture, and please do like, comment, and subscribe to our channel. Thank you.